Has anyone ever mentioned common law marriage to you, and were you a little bit confused as to what that meant? Do you know there are two definitions of the word civil law, and one is what is usually mistaken for Napoleonic law? Yeah, like the kind they use in Louisiana. Have you ever wondered why an old Volkswagen has its engine in the back? I have answers for all of these questions and possibly several more. Hi guys, welcome to an episode of Civics and Car Mechanics, where I attempt to fix my car unsuccessfully and teach you a civics lesson, hopefully slightly more successfully. Now, I had a small fire in my 1970 Volkswagen, and my first step is to replace all of the melted and disgusting wiring. But the new wiring comes in like one long string that you just sort of tie to the old wiring and then just pull through. And it is not being cooperative. Anyway, I decided while I was here, I was going to tell you a little story. As we try to make some progress on this little project I'm working on. So there are some phrases and some terms you'll hear thrown around relate to the words common law and civil law. I am currently wearing an LSU law sweatshirt, which was by accident, but it gives you a particular piece of insight on my legal education. See, I went to one of the few law schools in the entire world that teaches both common and civil law at the same time. Now, this is using the term civil law in a different way than you may have heard it in the past. Generally, when we talk about civil law in the United States, we're talking about the difference between a criminal law case and a civil law case. Criminal law being something where you get in trouble, civil law being something where you're arguing over money. There's another definition of civil law that is far older, reaching all the way back to Roman times. And that version of civil law is the style of law that is currently in place in the state of Louisiana. Also in France, in large parts of Europe, South America, generally any major jurisdiction that was not ruled by England is a civil law jurisdiction. And I will explain to you the difference. Okay, that didn't go as well as I'd hoped. All right, so let's talk common law first. Common law originated in England. It's the style of law where judges write opinions and those opinions become law. In England, the king or queen's bench was made up of layers of courts, just like we have here with the circuit courts and the district courts. And the circuit court was literally a circuit where a judge who was an appellate judge would be driven around on a circuit from small town to settle higher level disputes. But once a circuit court judge had made a decision, that became the law for all of the lower court judges within that circuit. But over the course of time, a lot of things came to be defined through case law, through common law. And so a lot of crimes were defined that way, a lot of stuff. Like basically the entirety of English law was defined through these judicial cases over hundreds of years. And so rather than have a definition of, say, burglary written down somewhere, you would look back to what the court defines as burglary. It was what we call the common law definition of burglary. And today we still use the phrase common law definition often to refer to an early definition, because when the United States became the United States, we just basically took over the entire English common law and all of the definitions and rules that came with it. When we say common law marriage, what we're usually referring to is the fact that courts have said, if you live together for X amount of time, we're going to consider you married. Therefore, we're going to call it a common law marriage if you've been living together long enough. But we didn't just inherit the definitions. We also inherited the general concept of common law. This was the idea that in a higher court opinion, a judge would define something, and from that point on, all of the courts below him would have to follow that definition. It would become law, and that's how a lot of laws were written. Today, we refer back to a lot of common law definitions when we talk about the history of certain laws, because it is important sometimes to see how a law has evolved in order to figure out what it means today. Sometimes, if you're curious about what a particular word means, you need to see what it was changed to or from to understand what they were trying to do when they changed that word. So sometimes you have to go all the way back to the common law definition of that crime to understand why it is what it is today. It's not really on topic, but I told you I'd explain why Volkswagens have engines in the back. The front of a Volkswagen is filled with wires and whatever kind of junk I've thrown in there. The engine is back here. You notice how most cars have a grill in the front? That's because there's a radiator recycling coolant through the engine. Bug doesn't have this because it's what's called an air-cooled engine. Instead of using coolant, it just directs air under the car, sucks it up into the engine, and cools the oil directly. And yes, just in case you were wondering, the older air-cooled buses also have their engines in the back. So civil law began in Rome. It's very, very old. It was originally created by a guy named Justinian. He wrote the Corpus Juris Civilis, which is like the book of Roman civil law. And it's a very ancient book of codes. It's statutes. It's laws about everything. And it was used, and it's been used on and off throughout history. But its most famous sort of revival came with Napoleon, which is why a lot of people mistakenly refer to Louisiana law as Napoleonic Code, when in fact it is really based on Justinian and a little bit of Spanish law. At the time that civilian law was instituted in France, there was a real problem going on because they had a similar system to England, where there were judges around who had a lot of power to write and enforce their own laws. The problem is that the judges were extremely corrupt and people did not trust the judges. So when they went to institute a new system of law, they were like, we don't want judges having any power to write law. So we are going to go in the opposite direction. In France, guided at its base by some version of the Corpus Juris Civilis, the only body that can write law is the legislature. And no decisions by a judge, no matter how high the court, including the Supreme Court, are actually binding on lower court judges. So this is one of the big dividing lines between a civil law jurisdiction and a common law jurisdiction. In a common law jurisdiction, judicial decisions are law. In a civil law jurisdiction, they are not, and they cannot be. This is why when you hear people complain about judge-made law, they are seriously misunderstanding the kind of legal system that we live in. We have always lived in a common law jurisdiction, and that is at the root of it. So real quick, America, common law jurisdiction. If a district court judge makes a decision that I don't like, I can appeal it to the Circuit Court of Appeals, and if the Circuit Court of Appeals goes the other way, that decision will be binding on the district court judge. We'll have to go back down and he'll have to make a new decision in line with what that circuit court judge said. That circuit court judge's decision binds the lower court judge. In France, and to a lesser extent Louisiana, a civil law jurisdiction, things are a little bit different, although they are a little bit confusing. If I file a court case in the equivalent of a district court and I don't like the outcome, I can appeal it to a higher court. That decision may be sent back down to the district court, but the district court doesn't have to follow it. So the district court can go the same way they went the first time. I can take it back up to the appellate court, who can go the same way they went. I can take it to the Supreme Court, who can go the same way the appellate court did. But we can go around and around all day. No one is required to follow the higher court decisions. That said, my understanding from going to LSU law is that it is uncommon for the higher court decisions to be ignored. Also, interestingly, just as a higher court decision is considered when a lower court makes a decision, a learned scholar's opinion may also be considered. So a law school professor might write a textbook on something, and that book may be read with as much impact as a higher court judge's opinion. In theory. So to recap, a civil law jurisdiction relies more on legislation, and they have a civil code that they use at the base of everything. It is a lot of laws about every little specific thing. Whereas we have a constitution that is nice and short and a lot of case law to explain it, they have a civil code that is very long and do not rely on case law to explain it. In America, civil court is about paying your debt to another person. Criminal court is about paying your debt to society. All right, I got it. I got it through. Thanks for coming with me. So this is the new wires.